Hello, and welcome to the OCO Roundtable podcast. From Oraro & Company Advocates, my name is Melanie Mwenda, and I am your host today. I have the pleasure of hosting John Mbaluto and Natalie Obago, who are part of the firm's data protection team. John is the Deputy Managing Partner at the firm in the Dispute Resolution Practice Group. With over 15 years' experience, John has represented and advised local and international clients, particularly in construction law, employment and labor law, pension law, banking and commercial disputes, data protection, and constitutional law. Welcome, John.
Thank you for having me.
Natalie is an associate in the firm's Dispute Resolution Practice Group and specializes in general contractual disputes, employment and labor law, land disputes, insurance law, data protection law, product liability disputes, and constitutional law. Welcome, Natalie.
Glad to be here.
As you might be aware, the firm's data protection team has in the last few weeks released various episodes in its data protection series. Today's episode focuses on the top decisions of the Office of the Data Protection Commissioner. For starters, the Office of the Data Protection Commissioner is the state office tasked with ensuring appropriate handling of personal data in Kenya. As part of its mandate, this office, under Section 8 of the Data Protection Act, receives and investigates complaints on breaches of rights under this Act. Furthermore, under Section 56 of the same Act and the regulations, once it receives a complaint and upon determination that the complaint falls within its purview, this office admits the complaint and it is required to render its determination within 90 days. Now, today's episode looks into 5 of these recent determinations and the penalties that can be imposed for non-compliance with the Act. So let's kick it off with you, John. I hear that our next case is a favorite of yours. This is the Melanie Mwenda case wherein the ODPC was called upon to determine the question of vicarious liability when handling personal data. Kindly tell us more about this case.
Well, I think before discussing the data protection lessons from the Melanie Mwenda case, it is important to mention a preliminary issue which came up for determination, which was a question of jurisdiction. So whereas parties had pursued alternative dispute resolution, they actually failed to settle the matter, which prompted the complainant to refile the complaint. Safaricom argued that since the Office of the Data Commissioner is required to investigate and determine complaints within 90 days, the refiled complaint was actually time-barred. The Office of the Data Commissioner was therefore called upon to decide whether it actually had the jurisdiction to hear the matter, and upon finding that the complainant had resubmitted a fresh complaint, in accordance with Section 56 of the Act, the Office of the Data Commissioner found that it actually had the jurisdiction to determine the matter. In effect, it was found that since there was a fresh complaint, time had not begun running. Now, the Melanie Mwenda case is actually similar to a famous case that stems from the United Kingdom, which is the case of W.M. Morrison Supermarkets versus various claimants. This is because in both cases, the adjudicating bodies were called upon to determine whether an employer is vicariously liable for the data privacy breaches of its employees. In the Melanie Mwenda case, the complainant discovered during separate court proceedings that Safaricom had disclosed her firm's and her personal M-Pesa statement without her consent or knowledge. In its response, Safaricom highlighted some of the organizational and technological measures that it has in place to eliminate data breaches. When put to its defense, Safaricom argued as follows. Number 1, that their employees are bound by an acceptable usage policy, which requires them to comply with all the information security and privacy policies, which include various procedures and guidelines. Also, Safaricom argued that the policies provide that the information acquired by their employees can only be accessed by third parties upon obtaining either consent or in compliance with a court order. Safaricom also argued that it had various safeguards in place, including access controls, logging and monitoring controls, quarterly audits, multi-factor authentication, and a virtual private network, also known as a VPN, which its employees were required to use before accessing personal data. Despite these measures, Safaricom did admit that upon carrying out investigations, It had determined that one of its employees, named Dorcas Mwaniki, had released the complainant's personal data without Safaricom's authorization and in complete disregard for the terms and conditions of her employment. Safaricom confirmed to the Office of the Data Commissioner that as a customer care agent, Dorcas had access to the M-Pesa statements in her ordinary course of work. But under the terms and conditions of her employment, Dorcas was supposed to supply these M-Pesa statements to third parties only upon request by the data subject or in compliance with a court order. Like the court in the UK that determined the Morrison supermarket case, the Office of the Data Commissioner grappled with the question of whether there was a sufficiently close connection between the employee's work and the breach in question to warrant liability, what is known as vicarious liability to be precise, on the employer's part. Upon applying the close connection test to determine whether Safaricom was vicariously liable for its employees' actions, the Office of the Data Commissioner determined that whereas Dorcas extracted M-Pesa statements as part of her field of activities, she was in fact not authorized to share these statements with third parties. The Office of the Data Commissioner made this determination against the backdrop that Safaricom had in place sufficient safeguards to ensure its customers' privacy and safeguards which Dorcas simply did not adhere to. The Office of the Data Commissioner held that Dorcas had breached the Data Protection Act and therefore assumed personal responsibility under Section 72 of the Act. It is noteworthy that despite holding Dorcas personally liable and recommending her prosecution for unauthorized disclosure, the Office of the Data Commissioner warned that employers should not take this determination as an absolution on vicarious liability. Thus, employers are tasked with ensuring that they have robust data protection mechanisms in place. Of note from this decision is that Safaricom was able to satisfy the ODPC that it had appropriate safeguards in place to protect personal data and that the unauthorized disclosure was by an employee who had proceeded on a frolic of her own. Further, by holding Dorcas personally liable and cautioning employers against viewing this determination as a free pass, we see the ODPC actually reinforcing the need to foster and entrench a privacy culture within an organization.
Thank you for sharing those insights with us, John. I think that becomes a very important case for employees and employers alike in ensuring that they're building a privacy-centric environment, as we had talked about in the second episode. Now let's move to a different case. So in August 2023, there was a frenzy on social media where the Office of the Data Protection Commissioner issued a penalty notice of 4.55 million Kenya shillings against Roma School, which is based in Utheru. This was the first and the highest penalty that had been issued to an educational institution. So Natalie, tell us more about this case.
Well, Melanie, in May 2023, the ODPC received a complaint from a parent whose child was enrolled at Roma School. The parent informed the ODPC that the school intended to upload videos of children on its TikTok accounts without consent from the children's parents. She stated to the ODPC that the school had notified the parents in a WhatsApp group that they would be using these said TikTok videos to, one, showcase the children's talent and to market the school. The parent was concerned about how her child would be exposed on social media through these TikTok videos. The parent, Christine, inquired from the school what measures they would take to ensure that their children's personal data was processed in accordance with the Data Protection Act. The measures she was talking about were these organizational and technical safeguards we talked about in episode 2. Together with other parents, the complainant, Christine, requested for a copy of the school's data protection policy. However, the school not only failed to supply the parents with the protection measures that they would be taking to protect the children's data, but also failed to furnish the parents with a copy of the data protection policy. Hence why Christine filed the complaint with the ODPC. We picked this Roma School determination as one of the 5 ODPC decisions as it sheds light on how the ODPC deals with cases involving personal data of minors. Article 53(2) of the Constitution of Kenya provides that a child's best interest is of paramount importance in matters concerning children. What this means for stakeholders is that whenever they are making decisions affecting children, they need to think, what is the best interest of this child? Furthermore, given the sensitive nature of this particular data set, Section 33 of the Data Protection Act regulates how this category of personal data is handled. For instance, and of relevance to this case is that under Section 33 of the Act, before processing a child's personal data, a data controller or processor is required to obtain consent from the child's parent or guardian. Secondly, under Section 33, the data controller or processor must ensure that the processing activity is done in the child's best interest as required under the Constitution. The Act places a further obligation on data handlers to incorporate mechanisms to verify a child's age and obtain consent, as earlier discussed. In interpreting Section 33 of the Act, the Office of the Data Protection Commissioner observed that the said section is couched in mandatory terms. Therefore, upon reviewing the submissions made by the parties, the ODPC determined that Roma School had indeed violated several provisions of the Data Protection Act for various reasons, some of which include: 1. The school failed to give a valid explanation as to the reasons for posting minors' personal data. In this regard, the ODPC recognized the place of informed consent. That is, under Section 25 of the Act, a data controller or processor is required to ensure that personal data relating to family matters or private affairs is collected only where there is a valid explanation. This is what we call informed consent. Secondly, the ODPC found that the school had attempted to deny the complainant the right to object to the processing of her child's image despite the provisions of Section 27 of the Act, which provide that a parent or guardian has the authority to exercise rights on behalf of a minor. This decision reminds us of the standards that ought to be upheld when handling personal data relating to minors. It underscores the need for educators to obtain explicit consent from parents or guardians and prioritize the best interest of the child. Further, data controllers and processors need to be at all times cognizant of the rights accorded to data subjects. Lastly, the Roma School determination is particularly relevant now that the ODPC has released a guidance note for the education sector. This was in December 2023. This is because education institutions can apply these lessons, the lessons from this determination and the guidance note, to ensure compliance with the law on data protection.
Thank you for that, Natalie. To our listeners, feel free to check out our legal alert on the guidance note for the education sector on our farm's website. It has been said that one of the main problems with data storage is that, unlike human beings, the internet doesn't forget. I'm aware of the famous Google versus Spain case, where the European Court of Justice ruled on whether a data subject could demand a search engine to remove certain information from its index. John, can you highlight for us a case where the Office of the Data Protection Commissioner has determined this issue of the right to be forgotten?
Sure, but before delving into the next ODPC case, let me expound a bit on the Google v. Spain case, which you rightly term as famous. So in 2010, Mario Gonzalez, a Spanish citizen, filed a complaint with the Spanish Data Protection Authority, seeking to have a local newspaper and Google Spain remove articles and corresponding web links relating to the auction of his property arising from attachment proceedings for the recovery of social security debts. He argued that these attachment proceedings had been resolved years ago and that reference to him in the present day was irrelevant. In the Google v. Spain case, the European Court of Justice determined that since Google handles personal data, it, as well as other search engines, were data controllers. The court further determined that a data subject has a right to be forgotten, which can be enforced against search engines which in turn give data subjects more control over their personal data. So in effect, Google was told to update its records so that Mario Gonzalez could effect his right to be forgotten whenever somebody conducts a search. Closer home, in the case of Erastus Mbaka versus Metropole Credit Reference Bureau Limited, the Office of the Data Commissioner was called upon to determine whether the listing by Metropole on the Credit Reference Bureau, which I shall hereinafter call the FCIArb, was inaccurate, and whether Erastus was entitled to an order for deletion and the reassessment of his credit score after the deletion. Here, the complainant argued that the Law Society of Kenya SACCO, now called the LSK SACCO, an interested party in this case, had used his savings to settle another member's loan, which in turn led to the misrepresentation of his credit score and eventual listing on the CRB. Concurrently with this complaint, Erastus filed an action against the LSK SACCO before the Cooperative Disputes Tribunal. In its response to the ODPC, Metropole indicated that as a credit reference bureau licensed by the Central Bank of Kenya, it was required to maintain a database of customer information. Customer information which they obtained from authorized financial institutions such as the LSK SACCO, who ought to ensure that the information was accurate. Metropole further argued that deleting the customer information provided by the LSK SACCO would actually be in violation of Regulation 28 of the Banking Credit Reference Bureau regulations. So what happened in this case is that the Office of the Data Commissioner actually refrained from adjudication on the merits of the dispute because the crux of the case related to a similar matter which was before the Cooperative Tribunal between the same parties. However, the Office of the Data Commissioner noted that the complainant's credit information furnished by Metropole by the LSK SACCO fell within the nature of customer information to be shared as per Regulation 18 of the Banking Credit Reference Bureau regulations, and thus there was a legal basis for which that personal data was in fact processed. Whereas the Office of the Data Commissioner did not identify the specific legal basis under Section 30 of the Data Protection Act, it can be argued that this disclosure by Metropole was in compliance with a legal obligation to which it was subject to. It is on the foregoing basis that the Office of the Data Commissioner dismissed the complaint and informed the complainant of his option to relodge the complaint following the determination of the case before the Cooperative Tribunal.
That was very insightful, John. Thank you. At this juncture, I'd like us to move to a particular determination that touches on a scenario that would then affect each and every one of us. There has been a trend of data subjects taking legal action against companies which send predatory and unsolicited marketing messages and calls. Since April 2023, the Information Commissioner's Office in the UK has issued fines exceeding £2.59 million against such companies. One such example is Pinnacle Life, which was fined £80,000 for a predatory spam call campaign it ran for a year. So Natalie, do we have any similar determinations in the Kenya jurisdiction?
Yes, Melanie, we certainly do have a similar case here in Kenya. That is, the Office of the Data Protection Commissioner has been cracking the whip on companies that send unsolicited marketing messages. In this regard, in May 2023, 2 individuals filed a complaint against Premier Credit Limited for sending them unsolicited messages without their consent. In particular, the first complainant stated that Premier Credit sent him spam messages to take loans with them, yet he had not given them his contact details. On the other hand, the second complainant stated that Premier Credit publicized and used his number for marketing purposes without his consent. When put to its defense, Premier Credit denied handling the complainant's personal data, stating that it only handled personal data of data subjects that voluntarily interacted with the company's official number. They further denied that the numbers used to contact the complainants belonged to the employees. They also stated that all their direct marketing messages were sent via its official number registered as Premier Info, and that data subjects who received these promotional messages had explicitly consented to receiving the same. Premier Credit also stated that their promotional messages have visible, clear, and understandable explanation of how a data subject can opt out, basically an opt-out mechanism. Premier Credit also stated that their employees and agents are required to comply with their obligations under the Data Protection Act. They also stated that they sensitize their employees and agents on the various laws in respect of data privacy, in particular, advising their employees against sending direct marketing and promotional messages using their personal numbers. However, lo and behold, when the ODPC conducted its investigations, they did determine that the numbers used to send these promotional messages to the complainants were not registered to the company's employees, but instead were registered to Premier Credit's independent sales agents. So basically, Premier Credit's data processors. The ODPC further observed that the second complainant was indeed a customer of Premier Credit and had an active loan, and that made him a data subject of Premier Credit. Since these promotional messages were sent by a data processor of Premier Credit, the ODPC crystallized the issues for determination as three. The first one being whether Premier Credit had obtained consent from the complainants before sharing these promotional messages, whether Premier Credit had provided an opt-out mechanism in respect of these promotional messages, and whether, if at all, there was an infringement of the complainant's rights under the Data Protection Act. On the first issue of whether consent was obtained prior to processing, the Office of the Data Protection Commissioner considered whether Premier Credit had provided, or rather had furnished it with evidence of valid consent from the data subject, as required under Section 32 of the Act. Premier Credit did not adduce any evidence in this respect, which consequently led the ODPC to determine that it had failed to obtain consent from the two complainants prior to using their personal data for marketing purposes, which was a violation of Section 37 of the Act. Next, the ODPC considered whether Premier Credit Limited had provided an opt-out mechanism in its promotional messages to the complainants. Here in Kenya, you'd find that whenever you receive these promotional messages, they give you a sort of stop, and you can, use that code and then subsequently stop these promotional messages. And that's what we mean by an opt-out mechanism. Under Regulation 15 of the Data Protection General Regulations 2021, a data handler is required to provide a simplified opt-out mechanism, which allows data subjects to opt out of receiving direct marketing communications. To satisfy this requirement, Regulation 17 of the General Regulations prescribes that such an opt-out statement or mechanism must be prominently displayed to draw a data subject's attention. The ODPC found that Premier Credit had not produced evidence of any such opt-out mechanism and therefore were not in compliance with these regulations. Consequently, the Premier Credit had failed to provide a simplified opt-out mechanism to its promotional messages. Further, the ODPC noted that since Premier Credit had intentionally misled it to believe that the numbers used to contact the complainants did not belong to its agent, when in fact they did, this amounted to obstruction of the ODPC's functions, contrary to Section 61 of the Act. In this respect, the ODPC imposed criminal liability on Premier Credit. Section 61 of the Act provides that where a party impedes the ODPC in the exercise of its functions, the party commits an offense and is liable on conviction to a fine not exceeding 5 million Kenya shillings or to imprisonment for a term not exceeding 2 years or both. From what we've discussed earlier in respect of the opt-out mechanism, whether consent was obtained, whether consent was demonstrated, we see that the ODPC found that Premier Credit had violated the rights of the two complainants. And it is on this basis that they issued an enforcement notice against Premier Credit.
That's a decision indeed in the right direction. Thank you for that, Natalie. Moving on now to a different case. I'm aware that in the 18th edition of the Farms Legal in Kenya newsletter, you authored an article on a determination in respect of a data subject's capacity to file a complaint. John, can you tell our listeners a little bit more about that decision?
Thanks for the question, Melanie. This was a very interesting decision, and it concerned the firm of Wamai and Allen advocates who had filed a complaint with the Office of the Data Protection Commissioner against two of its former employees. Now, in its complaint, the partners at the law firm alleged that one employee, who was the first respondent, had disclosed personal data in respect to the law firm's clients with the second respondent, who at that time had left the firm's employment. The complaint was dismissed by the Office of the Data Protection Commissioner for a number of reasons, including that, one, the law firm did not have express authority to institute a claim on behalf of its clients, as is required under Section 27 of the Data Protection Act, and also that the law firm had not furnished the Office of the Data Protection Commissioner with the documents which they alleged were unlawfully disclosed by the respondents, and so it could not determine whether there had been a data breach. The law firm naturally felt aggrieved by this determination and moved to the Judicial Review Division of the High Court, seeking several orders, including to quash or set aside the determination by the ODPC. At the High Court, the court found that the complaint was not in fact investigated and determined within the statutory 90 days, which is set out under Section 56 of the Act. Consequently, the Office of the Data Protection Commissioner, according to the court, had no jurisdiction to issue the determination outside of those timelines. The High Court ordered that the complaint be readmitted and looked into afresh, with investigations being concluded within 30 days. When the matter was later readmitted for investigations by the Office of the Data Commissioner, it considered whether the respondents, as former employees, had violated the provisions of the Act and whether the law firm had capacity to institute a claim on behalf of its clients. On the issue of capacity to institute a claim on one's behalf or that of another, what we lawyers like to call locus standi, the Office of the Data Protection Commissioner affirmed that the scope of the Act is restricted to guaranteeing the privacy rights of natural persons and not legal or juristic persons. To this end, legal persons such as the law firm were excluded from filing a claim for breach of privacy rights because they had not demonstrated to the Office of the Data Protection Commissioner that their individual privacy rights had been violated. And secondly, the documents they had produced belonged to their clients, most of whom were also legal persons such as companies. Therefore, privacy practitioners ought to be mindful not to institute claims on behalf of corporates or other legal entities, as the same are not considered data subjects under the Act. Regarding whether the Office of the Data Protection Commissioner found that the respondents had unlawfully disclosed personal data, the law firm in this regard failed to furnish the Office of the Data Protection Commissioner with the documents that the former employees had allegedly shared without consent or lawful reason. Therefore, the Office of the Data Protection Commissioner found that it was impossible to ascertain whether there had in fact been any unlawful disclosure of personal data. Furthermore, the Office of the Data Protection Commissioner determined that most of the documents in question related to legal proceedings that were either publicly available, that is on the Kenya Law website, or on the firm's own website. In this respect, therefore, these documents were considered to be public records or matters in the public domain, and therefore were exempt from complaints relating to breach of personal data under the Act. Ultimately, the complaint was dismissed, with the Office of the Data Protection Commissioner finding that there had been no breach of the Data Protection Act. To conclude, privacy practitioners and even data subjects acting in their personal capacity need to be mindful of who this act applies to. That is, natural persons who are defined as data subjects under the act. It follows, therefore, that a claim cannot be instituted on behalf of legal or juristic persons.
That's a very interesting decision, John. Thank you for sharing your take with us. As we come to a conclusion on today's episode, what's your parting shot? John, Natalie.
Well, for me, I think it's exciting space around this act and the determinations or enlightenment provided by the ODPC through its determinations. And therefore, we are on, uncharted territory, and we keep trying to remain abreast with such decisions and sharing them with our listeners and our clients. So exciting times ahead as the ODPC continues to shine its light on this area of the law.
Well, Melanie, on my part as a data protection practitioner, I think these decisions are important for us to take stock, for us to see how best we can advise our clients on compliance and to just learn lessons from other entities on how to ensure compliance with the Data Protection Act.
Thank you for that, John and Natalie. If you found these discussions enlightening, we invite you to listen in to our other episodes in this data protection series. We value your feedback, and thus, we encourage you to reach out to us on our social media channels using the hashtag OCO Roundtable. Until then, goodbye and take care.